mask when they enter the well to give a opening, direct, cross, or closing. They have to wear their mask in the commute, if you will, to the well. So from council table to here, put it back on and return to council table. Witnesses are allowed to take their mask off while they're behind the plexiglass for the witness being crossed or directed. There are some other things that I'm probably forgetting, but the judge will cover those in preliminary matters, I'm sure. Just to give a brief explanation of this competition, this is a historic competition, and we're so happy that it's continued. I was telling some of the members of the firm earlier that the alumni of this competition include at least 2 Supreme Court justices. We have 2 former Supreme Court justices that have actually won this competition. Not to mention about 6 law school faculty and staff that have competed in this competition, and numerous attorneys from across the state and across the country that have competed in this competition. And so we are making history here today. Some of you could be those Supreme Court justices one day. We're excited to see that. With that, I'm going to turn it over to the bailiff and we'll get started. Where's the bailiff? 1 minute.
Because if you need a time check, there's going to be a running clock over here.
All rise. Moot Court 1 is now in session. The Honorable Judge Shakur person presiding. God bless the United States and this honorable court.
Thank you. Please be seated. We're here for trial proceedings in case of Kyle Wilkins individually in the capacity of representative of the estate of the minor Chris Wilkins versus New Columbia County School District. Civil action number 1812-96. Thank you all for being here, and thank you to the Mr. Dalehite. You made your remarks already? No, sir. I want to thank our sponsor, the Steen and Dalehite law firm. Mr. Dalehite is in the courtroom with us, serving as a juror, and have a few opening remarks.
Thank you, Your Honor. I have to take this off because when I put my glasses on, they fogged up immediately. So, the law firm of Steen, Dalehite and Pace was formed in 1980. In 1982, we were asked by a faculty member to support this competition, and we've done so since that year. Lanny and I, Steen, Dalehite and Pace, were formed in 2002, and we have continued the support of it. So this is the 38th year. I think I have been to 37 of them. So I think I've got it down pretty well by now. I introduce our firm. This is Seth McCoy, Heather Nicholas, Anna Livingston, and Lanny Pace. It's a real pleasure for us to do this. We call ourselves litigators, so we're anxious to see some fantastic litigation here from you four. Thank you, Your Honor.
Thank you. Who do we have appearing for the plaintiff?
Good afternoon, Your Honor. My name is Alexander Coleman, alongside my co-counsel Bobby Marsh, and we're here today on behalf of Kyle Wilkins in the representative capacity of the deceased Chris Wilkins.
Thank you. Could you tell me your last name one more time?
Coleman.
Cole.
Yes, sir.
And Marsh.
Yes, sir.
And who is here for the defense?
Good afternoon, Your Honor. My name is Yanina Garcia, and I'm here along with my co-counsel, Zach Brand. We have the honor of representing the New Columbia School District. My co-counsel has an order of appearance for Your Honor's review. May he approach the bench?
You may.
Your Honor, may I ask that each stand to reintroduce themselves?
Yes. And you are Miss, how do you pronounce your last name again?
Garcia.
Garcia. Mr. Brand.
Yes, sir.
Do we have any pretrial matters to take up?
Yes, Your Honor. This is Mr. Coleman. We have a few housekeeping matters that we'd like to take care of before we proceed to motion and eliminate, Your Honor.
All right.
We've also prepared a order of appearance for Your Honor and opposing counsel and members of the jury. May I approach the bench?
You may.
Your Honor, we ask that all objection arguments be made constructively outside the presence of the jury.
Okay, we'll just assume that to be the case.
Yes, Your Honor. Now, we also like to know your preference on objection. Would you like for us to state the grounds and wait or provide a full evidentiary basis for the objections?
I'll ask for an explanation if I need it. You can just state the grounds for the objection. If I need an explanation, I'll ask.
Yes, Your Honor. We'd like to take judicial notice of stipulation 6 in the packet that all witnesses are pre-sworn.
That will be so noted.
Okay, we like to ask the court to invoke Rule 615 to constructively sequester all witnesses except for the party representatives. This case, our party representative for today's matter would be Pat Connor.
That request will be granted.
Yes, Your Honor. And we also like for the court to take judicial notice that all discovery obligations have been taken care of.
The court will take notice of that.
And this concludes our housekeeping matters, and the plaintiff is ready to proceed to motion to eliminate, Your Honor.
All right. Does the defense have anything before we get to the motions and eliminate?
Yes, Your Honor. First, we'd like to bring to the court's attention to Local Rule 8, which states that the extensive law applicable to the proceedings is.
I'm sorry, I'm having a little trouble here.
I'm sorry, Your Honor. We'd like to bring the court's attention to Local Rule 8, which states that the extensive law applicable to these proceedings is the United States Constitution, the federal rules of evidence, and the federal rules of civil law, and the case law that statutes provide in the proceeding.
All right.
At this point, Your Honor, we'd also like the court to take judicial notice of the negligence statute, section 18101, specifically subsection B, which is the section on comparative negligence. As you can see from the statute in New Columbia, comparative negligence is not an affirmative defense. As such, although it may be different in various jurisdictions, the defense does not have a burden of proof on this matter.
Okay. Anything further?
No, Your Honor.
All right. Does the plaintiff have any motions and limit?
Yes, Your Honor. Please, the plaintiff move to exclude all mention and testimony involving and stemming from the liability release of Pat Connor. This is an inadmissible settlement negotiation and is directly prohibited under Rule 408 of the Federal Rules of Evidence, Your Honor.
What says the defense?
We have no objection to that, Your Honor.
Well, that request will be granted.
Yes, Your Honor. Then that concludes, or that is the end of our motion to eliminate, Your Honor.
All right.
Your Honor, before I proceed, I'd like to clarification. Are we allowed to take our masks off when we're talking like this? Is that?
Well, I believe the general consensus, since you are so close to co-counsel, that you should probably keep your mask on at counsel's table. But if you are in the well of the court examining a witness, then you may pull your mask.
Yes, Your Honor. Your Honor, in this case, we anticipate that opposing counsel will call Pat Connor, who is a track coach at Lincoln High School in New Columbia School District. We anticipate, based on statements made in Ms. Connor's affidavit, that she will make statements regarding attempt to make statements regarding the effectiveness and efficacy of security measures that were taken at Lincoln High School, as well as the effectiveness and efficacy of security measures that could have been taken. Ms. Connor is a track coach. She has received no additional education past her undergraduate degree. She has no special doctorate, master's, and has attended no training courses regarding the same. As such, we move to bar all testimony regarding the effectiveness of the security measures that could or could not have been taken under Rule 702, Rule 401, and Rule 403.
What says the plaintiff?
Yes, Your Honor. In regard to the witness's capacity under Pat Connor as a lay witness under Rule 701, the witness is directly allowed to testify in regard to things that are rationally based upon the witness's perception. Given the fact that Pat Connor has had a long tenure as the track coach of Lincoln High School, it would be within her direct capacity and perception to perceive the safety measures of the school. This would directly bar the objection of 401 and 403, and again, is a permissible testimony under Rule 701, Your Honor.
Your Honor, may I have a response?
You may.
Your Honor, while the witness may be allowed to testify as to what security measures were taken, specifically the effectiveness of it or the effectiveness of a measure that could have been taken is purely theoretical and therefore requires scientific, technical, or otherwise specialized knowledge, and is therefore required to lay their additional foundation on Rule 702. This cannot be based on a witness's rationally based perception and should thus be barred.
Your Honor, may I be heard if possible?
You may, but I'll allow the defense counsel to respond.
Yes, Your Honor. Your Honor, there is nothing theoretical about the perception of Pat Connor's capacity as a track coach and an extended tenure with Lincoln High School. Once again, this Pat Connor, the witness, has an extended tenure with Lincoln High School, and the witness has the direct knowledge of the security of the school and thus should be able to testify to the extent thereof, Your Honor.
Your Honor, we stand by our objection that while she may be able to testify as to what was taken, whether or not it was effective and whether or not other measures could have been more effective is purely within 702.
The court is persuaded by plaintiff's counsel that the opinion of this witness regarding the effectiveness or ineffectiveness of safety measures based on his own perception is permissible, and that motion to exclude that testimony will be denied.
Yes, Your Honor. Our second motion to eliminate stems from the second witness from the plaintiff, Dr. Devin Garnett. Based on the affidavit, Dr. Garnett, we anticipate that opposing counsel will attempt to enter an 8-point system for additional recommendations to the school. Certain of these recommendations are violative of the Constitution and applicable fire codes, namely random locker searches and random drug testing, which are violative of the Fourth Amendment's bar on unreasonable search and seizure, and the chains on emergency exit doors to bar them from being accessed, which is violation of fire code. We would move to bar these statements regarding these procedures on the grounds that it would be more prejudicial than probative. By presenting the jury with testimony regarding these potential things that they could have done, it gives the impression that New Columbia School District made a judgment call not to implement it, rather than it being a legal impossibility. As such, it's unduly prejudicial, confusing, and a waste of the court's time.
What says the plaintiff?
Your Honor, pursuant to Rule 703 of the Federal Rules of Evidence, an expert may base an opinion on facts and data in the case that the expert has made or been aware of or personally observed. May I proffer, Your Honor?
You may.
My witness, Dr. Devin Garnett, is going to take the stand today and directly testify that as a part of her procedure that she employed today in today's matter, that she spent a total of 10 days at the school and she personally observed, and she was hired to personally observe all things related to the security procedures and parameters of Lincoln High School. Therefore, due to the fact that the school directly hired Dr. Devin Garnett to offer her recommendation to the school, any recommendation that she made is not more prejudicial than probative, and its probative value substantially outweighs its prejudicial effect, and therefore should be allowed as admissible testimony for Dr. Devin Garnett, Your Honor.
All right.
Your Honor, if I may respond.
You may.
Your Honor, we do not deny that Dr. Garnett made these recommendations. Our particular issue is presenting impossible suggestions to the jury. Because the school district was prevented from random locker searches and random drug tests by the Fourth Amendment and by the fire code from chaining up the side doors, it has the tendency at best to give the jury a false impression that New Columbia School District made a judgment call. If the jury is capable of seeing through it and understands its impossibility, then it's simply a waste of the court's time. Either way, Your Honor, it's substantially more prejudicial and probative and should thus be barred.
All right. I think that any prejudice, if there is any, is something that would be better suited to carry on cross-examination. Therefore, I'm going to deny that motion.
Yes, Your Honor, and with that, the defense is ready to proceed.
Is the plaintiff ready to proceed?
Yes, Your Honor.
All right. Well, then, counsel for the plaintiff may make his opening statement.
May it please the court?
Before we begin, you turn off the video on your end.
May I proceed, Your Honor?
You may.
Sorry, we just turned that off.
Is it still on?
No, it's, just go ahead and have that one for a moment. Your Honor, we may take a recess so we can address technical difficulties with the screen.
All right, court will take a brief recess.
Judge, if you could turn on yours. Thank you, Your Honor.
All right. Court is now back in session. Counsel for the plaintiff may make his opening statement.
May it please the court? Free to move out the court, Your Honor.
Permission granted.
Opposing counsel? Members of the jury. How much is a life worth? How much is a teenage life worth? My name is Bobby Marsh, and I, along with my co-counsel, Mr. Alex Coleman, are honored to represent the estate of Chris Wilkins in today's trial. You see, Chris Wilkins, first off, if we were to ask Kyle Wilkins, Chris's mother, that very question, she would tell you that there was nothing on earth more valuable than her son, Chris. See, Chris was more than just a member of the LHS track team. He was a leader. He was a devoted student. And he was a cherished friend by all who knew him. On the day of March 29th, 2019, Chris Wilkins was preparing to run in the Tri-County Conference track meet as a member of the LHS track team. LHS was expected to absolutely dominate their competition on that day. After all, the track team does have they've already earned national recognition based upon their long-standing tradition of success. The success was due in large part to the efforts made by their star runner, Chris. On the morning of that big event, Chris was going through his normal school day routine, walking down the halls, going to classes, and we know that in between these classes at some point, Chris encountered Dan Peters walking in through a side exit door from the teacher's parking lot. And we also know that during this encounter, Dan Peters sold Chris drugs, which Chris took. Afternoon, as the team was going through their usual warm-up routine, preparing for the race, the fans noticed that their star runner had collapsed. Now, many people probably simply believed that Chris was cramping up. Maybe he hadn't drank enough water, something like that. But everybody was shocked to learn that Chris Wilkins was actually suffering from was a fatal heart attack. Rather than escorting her son to the podium after the big win, Kyle Wilkins was now escorting her son to the hospital. Rather than celebrating the victory, Kyle Wilkins was planning an unexpected funeral. See, we, the plaintiff in this case, have the burden of proof. And we have to prove to you, beyond a preponderance of the evidence, that the negligence of that defendant caused Chris Wilkins' death. Now, the preponderance of the evidence is a very confusing legal term. And honestly, it still stumps me. But the way I always remember it is it more likely than not true that the actions of the defendant make them liable? A good way to think about that is think about the scales of justice. If scales tilt in our favor, even just 50.0001%, then we win, and therefore we challenge you to deliver a verdict of liable. If it tilts in the other direction, by all means, the defendant wins, they should be held unliable. So in order to prove our case today, we're going to introduce you to a variety of characters. We're first going to hear from Coach Pat Connor. Now, Coach Connor was Chris Wilkins' track coach, a mentor, and someone who knew Chris intimately. I want you to listen as Coach Connor describes the invasive effect that drugs had on the student athletes at LHS amongst his own team. After Coach Connor, you will hear from Dr. David Garnett. Now, Dr. Garnett's going to get up and he's going to explain to you his perspective as an education safety specialist of the drug culture that LHS had. After all, Dr. Garnett attended LHS for 10 days. He walked the very same halls that Chris walked. Listen as Dr. Garnett explains to you what he recommended. Listen as he talks about his perceptions of the school, sort of as an outsider coming in to an insider, firsthand view. And after Dr. Garnett, we're going to hear from the man himself, the decision maker of LHS, Dr. Terry Taylor. When Dr. Terry Taylor takes the stand, I want you to pay particular attention to what we believe the evidence will show through Dr. Terry Taylor's testimony is that Dr. Terry recognized the issues that his school was presented with. But I want you to pay particular attention to what Dr. Terry Taylor chose not to do in light of knowing this. And finally, you will hear from Jamie Wilkins. Jamie Wilkins was a LHS classmate of Chris's. She was a teammate. She was supposedly a friend. But we believe that the evidence will show that even though she claims to be Chris Wilkins' friend, she was far from it. Pay particular attention when Jamie Wallace explains what she did not do to protect her friend. At the end of today's case, my co-counsel, Alex Coleman, will stand before you. He's going to review the relevant testimony that we've heard today. He is going to ask that you charge that defendant as liable for the death of Chris Wilkins. All throughout today, in conclusion, I'd like to challenge you all to continue asking yourself, how much is a life worth? And are the expenses that defendant put forth to protect and secure lives that he was charged and responsible for, do they match that value? Thank you, Doctor.
Thank you. Counsel for the defense,
Yes, Your Honor. Permission to move about the law.
motion granted.
May it please the court. Your Honor, opposing counsel, members of the jury. Unreasonable expectations lead to unintended consequences. That is what brings us here today. My name is Yanira Garcia, and I, along with my co-counsel, Zach Brand, have the honor of representing the New Columbia School District. Today, we will tell you about the unintended consequences that resulted in the loss of Chris Wilkins' life. Now, Chris Wilkins was an average teenager at an average school with average interests. His father, Kyle Wilkins, was an Olympic-level track star who failed to reach his career's pinnacle. In a final attempt to gain Olympic glory for his family, he pushed his ambitions onto his son, creating unreasonable expectations. Chris Wilkins felt the weight of the disappointment of his father and grew unsteady. Kyle Wilkins ultimately paid the ultimate price for his ambitions with the life of his son. Today, you're also going to hear about Lincoln High School in the New Columbia School District. Now, Lincoln High is a poor school in a worse neighborhood. Principal Taylor was hired at Lincoln High in an effort to make the school a safer place. And further, the New Columbia School District, in an attempt to make sure they were doing everything possible, hired Dr. Garnett to make an evaluation on the school on safety measures. You will hear that Dr. Garnett's recommendations placed unreasonable expectations on Lincoln High and Principal Taylor. Dr. Garnett's recommendations would prove so costly that Principal Taylor would be unable to even consider implementing them. If she had found a way to comply, she would have effectively taken away everything that makes a school a school. Now, members of the jury, I ask that you listen carefully today and ask yourselves, what is reasonable? The reason we have a reasonable standard rather than an explicit requirement is that it allows people such as yourselves to take into consideration the budgetary constraints of a person or organization and the limits that it places on them. Now, today the plaintiff is going to go over some measures they believe that the New Columbia School District could have implemented. And I want you to listen closely. When you hear of those measures, I want you to ask yourself, is that reasonable? What does it cost? Can Lincoln High afford it? Now, the plaintiff is using the unreasonable expectations created by Dr. Garnett to bring forth a charge of negligence under the Safe Schools Act. In order to succeed, they have to establish that the New Columbia School District owed Chris Wilkins a duty, that there was a breach of that duty, that Chris Wilkins was harmed, and that his harm was a direct result of that breach. Now, they have to prove each and every one of those elements to you by a preponderance of the evidence. And the judge will explain further what that means. But essentially, it means more likely than not. This is the lowest burden in our judicial system, and they will be unable to meet it today. But members of the jury, there's something else I want you to keep in mind. In New Columbia, we have something called comparative negligence. What this means is that we must take into consideration everyone involved to determine who is actually at fault. The New Columbia School District, Chris Wilkins, or Kyle Wilkins. Today, we're going to introduce you to two witnesses. The first of those witnesses is Principal Taylor. Now, you will hear from Principal Taylor herself of the measures she took and the lengths that she went to make Lincoln High a safer place. You will hear that she did absolutely everything she could, despite the budgetary constraints she faced, in order to decrease the prevalence of drugs and weapons at Lincoln High. You will also hear how the unreasonable expectations created by Dr. Garnett for her proved impossible. The second witness we will introduce you to is Jamie Wallace. Now, Jamie is Chris Wilkins' very best friend. And as Chris Wilkins' best friend, she's the only one who can tell you about the struggles that Chris was facing, the effect that it had on him, and the ultimate result on their friendship. Members of the jury, at the close of today's trial, my co-counsel will come up here and recount for you the unintended consequences that resulted in the loss of Chris Wilkins' life. At the end, we will ask that you find the New Columbia School District not liable. Thank you for your attention.
Plaintiff ready to call his first witness.
We are, Your Honor. This time, the plaintiff called Pat Connor to the stand. Permission to reconstruct the well, Your Honor.
I'm sorry.
Permission to reconstruct the well, Your Honor.
Yes.
If you would you hit the camera button?
Ms. Connor, if you'd like, you can take your message.
Please introduce yourself to the court.
My name is Pat Connor. I'm a longtime track coach for Lincoln High School in New Columbia.
And how long have you been the track coach at LHS?
About 15 years.
Tell us why you're here today, Coach Connor.
I'm here to bring justice to the Wilkins family. As an employee of the school, I witnessed a lot of areas where the school failed to step in and they should have.
Now, you mentioned the Wilkins family. What was your relationship with the Wilkinses?
Kyle and I met a long time ago. We met in college and we ran track together. We applied for the Olympic team and neither of us made it through that. We grew distant, as we moved off and had our own lives. But recently when I moved to New Columbia, we got in touch when his son Chris applied for the team in 2015, in his freshman year.
What was your impression of Chris's track skills when he tried out?
He wasn't great, but he had a lot of drive and enthusiasm and really seemed motivated, so I let him on the team.
How would you say Chris impacted the track team during his time with y'all?
He had a really big impact. Like I said, he probably started off as one of our least productive members, but became a star by the end of his senior year. But more than that, he was the heart and soul of the team. He kept everyone motivated to push harder and be better. And really, he kept the team together. But yeah, we really relied on him for everything.
If you had to pick just one moment, what would you say was the pivotal moment of Chris's track career?
That was, probably the worst moment, sadly. In his junior year, the state championship, he was up to run in two races, the 100 and the 200. And he got in 6th in one and then last in the other one. And that basically made us lose the championship. And I think we all just really were relying on him to win, and so his loss really brought the team morale down, and I think that's when we started putting more pressure on him.
Why do you pick this as a pivotal moment in Chris's career?
Well, like I said, I mean, that's the point when a lot of pressure started being put on him to be better and strive harder. My teaching abilities came into focus, and then after that is when he started to really increase and improve drastically in a short period of time.
Were these improvements suspicious to you, would you say?
At the time, I didn't really think anything of it. Like I said, I was under a lot of pressure to really increase our times and our scores because we are a state winning championship team and we have a record to keep. But looking back on it, he had a great increase of muscle mass and his times improved by at least half a second, which is pretty remarkable.
Coach Connor, what do you mean when you say pressure on the team?
I constantly felt like my job was at stake working there. As a championship school, you know, it's great and we have a lot of privileges and a lot of great athletes come to us with that, but it also comes with the downside and the negative atmosphere, having to be number one no matter what. And so if I don't win as a championship, my job is called into question constantly.
What makes you say your job was called into question though?
Principal Tyler regularly threatened to fire me, not just for that, but also if I didn't comply with any of what she was striving for and if I wasn't a team player.
What do you think the principal meant when they said team player?
I believe that was in reference to.
Yes, Your Honor, speculation.
Your Honor, if I may?
You can rephrase the question if you like, if that's what you, or if you want to
Can I respond
respond to
to-
objection, you certainly can.
Your Honor, the principal, Pat Connor is simply telling us their own present sense impression as to what they personally believe that the principal meant when they were threatening her position. Therefore, it's definitionally not speculation under the federal rules of evidence.
I'll allow her to testify as to how she perceived the communication.
May I re-ask my question, Your Honor? So, Coach Connor, what led you to believe that your job was at stake?
Well, is this about the team player comment? I'm sorry, I'm confused.
Yes, I'm sorry.
Okay,
Sorry,
sorry.
yes. Well, what did you mean? What do you think, what do you believe Principal Taylor meant when he said team player?
Well, Dan Peters was a previous member of the track team, and just like Chris was also a star runner that we really relied on. But he got caught smoking in the bathroom.
Yes, Your Honor, hearsay.
Your Honor, well, once again, the witnesses.
What exactly do you contend is hearsay?
The method in which she learned that Dan Peters had, it's a combination, lack of foundation and hearsay, Your Honor. The only way she could know what Dan Peters was caught with was by someone telling her.
Well, I think she's just testifying to it as a fact. She's not testifying to anybody that somebody told her.
Yes.
Your Honor, it is our contention today that Pat Connor is mistaken, and as such, we need her to lay the foundations to how she learned this information, so that we can establish.
I'll let you go into that on cross-examination.
Yes, Your Honor.
Thank you, Your Honor. So, Coach Connor, what happened with this incident with Dan Peters?
Like I said, he was caught smoking in the bathroom, but they also found a lot of steroids on him. And usually that's ground for immediate expulsion, but he was only given a few days suspension, and then I wasn't allowed by the principal to remove him from the track team because we really needed him and I needed to be a team player.
And was Dan punished in any other way besides that?
Not that I know of. Like I said, I think he just had a few days suspension, but the track team really took it as there was no repercussions for them.
Coach Connor, we mentioned drugs a few times today. Would you say drugs were an issue at LHS?
Absolutely. We live in a pretty bad area, and so there's drugs outside the school, and regularly I see at least probably 10 students a day, which with symptoms like glassy eyes and goofy smiles that I would consider being high. There's also
Complete speculation as to what the effect of that. There are many other reasons why someone could have glassy eyes and smiles that they would particularly be high is directly speculation.
Your Honor, if I may.
But
Coach Connor is simply testifying as to what she believed in her longstanding experience at the school was causing those effects.
I'll allow her to testify as to her beliefs based on her own experience and observations.
Thank you.
Can I
Can I re-ask my question, Your Honor?
You know.
So, were drugs a major issue at LHS from your perspective?
Yes, in fact, just a few years prior, in 2016, a student died in first period after getting drugs right off of campus or in the parking lot.
Did you ever notice an effort to curb this phenomenon?
Kind of. Principal Tyler was pretty good when he first came in. They instituted a safety zone, and then also created a board for safety, which I was a member of. And like I said, at first we took into consideration and hired like an extra security guard. But then quickly after that, any idea that we as the board presented to the team was quickly shot down.
And what kind of suggestions did you give them, like these recommendations from the board?
More metal detectors or security guards, because some of the ones weren't very productive. Hosting faculty workshops to monitor and teaching faculty how to recognize and monitor students and their drugs, because we all felt like drugs were a major issue. And then also issuing like student IDs and to students and faculty, so we knew exactly who was on campus at all times and that they were supposed to be there.
Now, why do you believe the principal would reject these recommendations from the board that he created?
Well, his reasoning was that we didn't have the finances for it, but then even our other recommendations, such as like a parent-teacher volunteer group, was shot down because it was bad for our public image and things like that.
Were there any other sort of recommendations that you all gave to Principal Taylor?
One of the main was drug testing our student athletes like other schools regularly did, but that was also considered not good because we could trust our students.
Well, now I want to take you to that day, to March 24th, 2019. Could you tell us what happened on that day?
Yeah, everyone was really excited, especially Chris. He was pretty much a shoo-in to win that track meet. And we were stretching and getting ready, and then he collapsed. And then it turns out that he had a heart attack, I guess, from overdosing on the steroids just before the game began.
Coach Connor, what sort of things did you do to prevent this steroid usage once you knew about it?
Well, I always knew there was a problem, and we talked to our team regularly, trying to get everyone more aware and tell my students that it wasn't acceptable, but the atmosphere in the school just wasn't conducive for my efforts.
And why did you overlook Chris's steroid usage?
Like I said, I was under a lot of pressure after that meet as well, and I felt like my job was at stake, and so I just didn't put enough proper care as I should have as an employee and as a coach.
And Coach Connor, just one last question. As you look back, could you have done more to help save Chris?
Absolutely. If I wasn't so stressed and worried about the school's reputation, I think I could have probably saved his life.
Your Honor, I now tender this witness.
All right. Cross-examination?
Yes, Your Honor. May I proceed, Your Honor?
No.
Good afternoon, Ms. Kyle.
Good afternoon.
Now, I want to clarify something here for the court. Now, you wrote a statement before today's trial, is that right?
Yes.
And you included everything relevant in that statement.
Yes, I believe so.
So we can trust that the extent of your knowledge on this situation it was written down in that statement. You say that that's fair?
Yeah, probably just about everything.
Okay. Now, one of the things you mentioned on direct examination was your relationship with Kyle Wilkins. I want to talk about that for a second. Now, you knew Kyle from college, is that correct?
Yes.
And at college, you two were both on the running team together.
Mm-hmm.
You both tried out for the Olympics.
Yes.
There was probably quite a bit of pressure on you to succeed at the Olympic level. Would you say so?
Oh, yeah. All of us, I mean, you don't get any younger for the Olympics, so it's really a once in a lifetime shot.
And that because of that pressure, you actually turned to steroid use. Is that true?
Objection, Your Honor. Relevancy.
Right.
Your Honor, this is directly relevant. As opposing counsel mentioned on the direct examination, Ms. Connor had extensive experience with Chris, if I may proffer. This line of questioning will go to show that she has previous experience with steroids, so she knows the signs of steroid use personally. That goes to either her ability to spot it or the effectiveness in which Chris Wilkins hid his steroid use from the people closest to him?
Mr. Morrow, your response?
Yes, Your Honor. Any steroid usage by Coach Connor was long in the past, well before she ever came into contact with Chris Wilkins. More so, Your Honor, the probative value of this is substantially outweighed by how prejudicial this information would be to the jury.
The objection will be overruled, and persuaded by counsel's explanation of the relevance regarding witnesses' ability to perceive the effects of steroids.
Thank you, Your Honor. Sorry, to re-ask that question, you turned to steroid use as a result of the pressure from the Olympics, is that right?
Kind of. I got really sick right beforehand, and so I felt like that was the only way for me to catch up and make it back to where I was right beforehand. But it's easily the worst decision I've ever made.
And so as a result of that, you never made the Olympic team, is that true?
Yes.
Now, Kyle also did not make the Olympic team, is that right?
Yes.
And you lost contact with Kyle until Chris Wilkins became a student at Lincoln High School, is that true?
Yes.
Chris Wilkins, when he first tried out for the team, did not make the running team, did he?
Yeah, he wasn't great.
You would say he didn't have his father's running genes at all, is that right?
No, but like I said, he had a lot of drive for it, so I gave him a chance, which,
Well, it was only after you spoke with Kyle Wilkins that you gave him a spot on the team, is that true?
maybe. Like I said, I was kind of deliberating and still hadn't put out the information yet, but he told me that he was pretty much devastated at his scores and he really wanted to improve, so yeah.
I want to clarify with the court, you spoke with Kyle Wilkins and then you let his son on the team, is that true?
I mean, yeah, we had a conversation beforehand, but it didn't influence my decision.
Now, in your capacity as track coach with Chris Wilkins, how many hours a day would you say that you practiced?
We try to do running every day after school for at least a few hours. And then I'm there early in case someone occasionally wants to go before school as well.
So a couple of hours a day, we say about 4 hours a day?
Yeah, probably 2 to 4, depending on the person.
And you said every day after school, so 5 days a week?
Well, like I said, it kind of depends on what you're running. We don't do every track event every day, but probably about, I'd say like 2 hours a day, a week, because it kind of.
So you functionally spent about 10 hours a day with Chris Wilkins, right?
Yeah.
And you still never suspected Chris Wilkins of steroid use, is that right?
Well, like I said, I noticed the symptoms, but at the time, he wasn't my first priority.
But you did suspect other people on the Lincoln High School team of using steroids, is that right?
Yeah, I've had suspicions in the past, but the school didn't care.
But never of Chris.
I don't think so, not at the time. Like I said, I was really self-absorbed during that time period, so I didn't honestly pay attention to any of them individually, like I should have.
I need to clarify this point. I'm sorry to go over this again. During that time period, right before Chris's death, you actually suspected 2 other Lincoln High School students of using steroids, right?
A bit before, yes.
But you did not suspect Chris of using steroids, is that yes or no?
No, I noticed the symptoms, but it didn't.
Nothing further, Your Honor.
You're right.
If I may, Your Honor.
You're right.
Coach Connor, why are you here today?
I'm here because,
Objection, Your Honor, outside the scope.
Your Honor, if I may.
You may.
Your Honor, this is definitely not outside of the scope of today. After all, the witness is about to explain to us her very reason for being here and testifying in this matter.
Your Honor, typically it's outside the scope of my cross-examination.
And what line of questioning and cross is this related to?
Your Honor, this line of questioning is directly related to the motivations of Coach Connor.
I never addressed the motivation of Coach Connor to testify in today's trial.
The objection will be sustained.
Thank you, Your Honor. Anything further?
Thank you, Mr. Honor. You may stay there. Plan to have any other witnesses?
Yes, Your Honor. I'd like to call Dr. Devin Garnett to the stand, Your Honor.
Dr. Garnett may come forward.
Your Honor, may I have permission to deconstruct the well?
Granted.
Freedom vote below, Your Honor.
You may.
Please introduce yourself.
My name is Dr. Devin Garnett.
And what is it that you do?
I own and I operate educational safety consulting. We perform safety evaluations for schools who want to set up and improve their safety programs.
And what is your occupation, or what is your role with the educational safety consulting?
Well, it's actually a business that I started back about 4 years ago.
How long has this company been in place?
Since then, so 4 years.
Okay. Now, could you give us a little bit of insight into your educational background?
Yes, I'm a graduate of Western University where I majored in criminal justice. Once I graduated, I decided that I wanted to study school safety issues. So at that point, I enrolled in Detroit University where I graduated with a PhD in security administration.
Do you have any additional experience in either education or security?
Yes, so before beginning my PhD program in between schools, I was a high school teacher for 3 years in Detroit, and I taught U.S. government. While I was there, the dangers facing both teachers and students in today's society became very prevalent to me. So I saw firsthand what happens when schools don't take accountability for their actions. At that point, I attained my PhD, and then afterwards, I worked for the U.S. Department of Education, which I spent my time analyzing ways to make schools safer.
Now, you mentioned the U.S. Department of Education. What all did you learn while you were there?
Sure. I developed my research skills a lot, and then I also learned various methods of lessening the negative aspects of school that many of our youth face today, such as bullying, games, and definitely drug use. It's especially true of drug use because it's very widely used, unfortunately, among youth today.
Dr. Garnett, why are you here today?
I'm here today because the New Columbia School District contracted my company in December 2017. We were asked to analyze the security system of Lincoln High School and to offer recommendations on how to improve the security at the school.
Now, did Lincoln High School, did they pay you by chance?
They have not finished paying me, but they paid me some.
Okay. Now, what principles and methods did you rely upon to reach a conclusion in today's matter?
Several things, but for example, I was in attendance at the school for 10 consecutive days to observe the atmosphere of the school. I also came up with a two-step analysis process to help fix the school's woes, which I utilized at Lincoln High.
And that two-step analysis, is it used in your field?
Yes, it's very widely used in my field.
Now, what facts did you rely upon in today's matter?
Well, I use both objective facts and subjective facts, because I think that's critical when analyzing security systems. For example, I interviewed students while I was at Lincoln High School, and like I said, I attended the school for 10 days where I observed personally their safety measures and what they could do to improve.
Was this a sufficient amount of facts for someone of your nature and your area of work?
Yes, definitely. It's the usual amount of facts and data used by experts in my field.
And tell me something, did you apply these principles and methods to the facts at hand today?
Yes, I did.
And did you reach a conclusion today?
Yes, I did.
Do you stand by your conclusion today?
100%.
Your Honor, at this time, I tender Dr. Devin Garnett as an expert in school security administration with a concentration in drug use prevention.
Any objection?
We don't object to Dr. Garnett being certified as an expert in the field generally, but would request permission of voir dire on how they're an expert on this particular matter.
Any problem with any part here? You may do that now.
Thank you, Your Honor.
Good afternoon, Dr. Garnett.
Yes,
Dr. Garnett, you mentioned that you use a two-step system in evaluating schools, correct?
correct.
And those are the only two steps that you need in completing an evaluation?
Yes, it's very efficient and effective.
Thank you, Dr. Garnett. Now, there are 25 schools in the New Columbia School District, is that correct?
Yes.
And you've studied a few of those schools?
Yes.
Now, studying here means collecting information about schools such as their location or the population, things like that?
Yes.
And you've only personally visited Lincoln High specifically, correct?
Yes, that's what I was hired for specifically.
Thank you, Dr. Garnett. Your Honor, at this time, we would object on the grounds of Dr. Garnett being certified as an expert on this particular matter. By her own admission, there's 25 schools within the district. She's only evaluated 8 of them personally, yet chooses to rank Lincoln High among the 25 totally. That's improper opinion.
May I be heard, Your Honor?
You may.
Your Honor, as the witnesses just briefly testified about, this witness is, not only is the process that the witness just described widely and generally used within her field, but she is the only witness of this capacity that could testify about the security measures of this school. There is, if I may proffer, Your Honor,
You might,
there are no other witnesses that are going to be called today that have the expertise and the tenure and the years within the field to be able to testify about this. Therefore, Dr. Devin Garnett should be tendered as an expert in the field of school security administration with a concentration in drug use prevention.
Your Honor, if I may.
you might.
We don't object again to Dr. Garnett being certified as an expert in the field generally. Our objection is strictly to being an expert as it applies to New Columbia School District. If opposing counsel would like on any line of questioning involving that, they can lay proper foundation. At this time, I just ask that it be limited in that particular way.
May I be heard real quick, Your Honor?
I think I've got enough. I'm going to overrule the objection. I'm going to accept
Yes, Your Honor.
the witness as an expert in the field in which she is been tendered. You may certainly go into those rounds of cross-examination.
Yes, Your Honor.
May I proceed, Your Honor?
You may.
Dr. Devin Garnett. Now, you mentioned this two-step process earlier. Could you elaborate for the jury what the purpose of that is?
Yeah, so the purpose is to analyze the school's effectiveness of giving existing security systems and provide recommendations on how to better them.
Now, are these measures effective?
Yes, definitely. Like I said before, I've spent several years both as a teacher in high school and with the Department of Education. So I was able to combine those experiences with my updated knowledge from my education and my PhD to form a research to cultivate this process.
Now, tell us something. Why is this process only 2 steps?
Well, that's the only 2 steps that I needed in order to collect the information to come to a conclusion. It's a common occurrence within the field that all security experts use the same 2-step process.
Okay. Now let's dive into it. What's step 1 of that process?
Step 1 is to identify the important features of the school, such as the school's location, number of students, prevalence of drugs and weapons, as well as how many security personnel they have on the campus.
And what was the purpose of doing this?
The purpose is to compare with other statistically similar schools and kind of get a judgment call from that point.
Okay, and what did you find?
Well, I found that this school's location and area can tell a lot about the school safety. It's really a sad reality that many students are a product of their environment. If the environment is conducive to drug use, then it's very reasonable to assume that students are going to succumb to the area that's surrounding them.
And are there any other elements to the first step of your analysis?
Yes, I take the objective information that I just talked about and I put it onto a chart and compare them to statistically similar schools.
Now, if I were to provide this chart that you just mentioned to you, would you be able to recognize it?
Yes.
Your Honor, let the record reflect that I'm approaching opposing counsel what has been previously marked as the safety statistics of Lincoln High School. Your Honor, permission to approach the witness?
You may.
We're approaching the witness with the same. Now, Dr. Garnett, for the court, what did I just hand you?
This is the chart that I was just mentioning where I took Lincoln High's statistics and tangible information and compared it to other statistically similar schools.
Now tell us something. How do you know what this chart is?
Well, I made it.
And have there been any substantial alterations or changes to this document since you made it?
No.
Is it in the same condition as when you finished the document?
Yes, it is.
Your Honor, at this time, I tender the safety chart made by Dr. Devin Garnett as evidence for Plaintiff's Exhibit A.
Any objection?
Objection, Your Honor, on hearsay and hearsay within hearsay.
Please elaborate.
Yes, Your Honor. Since Dr. Garnett compiled this actual report, I understand the elaboration, but Dr. Garnett collected the information that is contained within that report from other sources that are unknown. They are not cited on the report, nor is there any information as to where that information came from, meaning that definitionally it is hearsay within hearsay.
Your Honor, pursuant to Rule 803, subsection 6, this is a record of regularly conducted activity. We've already heard testimony from Dr. Devin Garnett that everything that she has done today is generally widely accepted within her field, and these such things are used in order to form her analysis and her conclusion. Therefore, this document in itself is an exception to hearsay. And in regards to the hearsay within hearsay, Your Honor, as the witness has already testified, she spent 10 days at the school and therefore was able to gather all of the information within itself. Therefore, Your Honor, this is an exception of hearsay, an exception to the rule of hearsay pursuant to Rule 803, subsection 6.
Any final remarks from the defense counsel?
Your Honor, may I have a moment to confer with my co-counsel?
You may.
Thank you. Your Honor, according to 8036, which co-counsel is using to bring in this form of evidence, it actually requires that they meet certain prongs. Specifically, I'd like to refer you to E of subsection 6, which says that they have to show that the information contained therein comes from a source of trustworthiness. Again, to my previous point, Your Honor, there's no information as to the sources that were used by Dr. Garnett, where the information was collected from, and therefore would definitionally still be hearsay within hearsay.
May I be heard, Your Honor?
No.
As the witness already testified, we know where the direct source of the information of the document came from because, again, the defendant themselves were the ones that contacted Dr. Devin Garnett to come to their school for 10 days in order to gather said information, in order to give them recommendations on how to fix the school. That is where the information came from, and that is why this is a regularly conducted activity pursuant to Rule 803, subsection 6, which happens to be an exception to the rule of hearsay, Your Honor.
Your Honor, if I may.
You may.
The chart contains information from 3 locations. Co-counsel is right. That does apply to Lincoln High School, the information that our client provided to them. However, Brookview High School and Patterson High School, we do not know where that information came from, what sources were used. Any information is not cited and therefore cannot be trusted at this time, according to 8036E.
May I be heard, Your Honor, real quick?
I'm ready to rule on the objection. The objection, I believe the operative rule here would be Rule 703, which allows, in other words, even if this information were to be hearsay, I'm not proving that it is, if it's factured down that was reasonably reliable by forming an opinion, then it may nonetheless be admissible and presented to the jury if it has sufficient probative value in helping the jury understand the expert's opinion. I find that to be the case, and I will rule the objection.
Yes, Your Honor.
May I continue, Your Honor?
You may.
Now, about this chart, what does it reveal to you?
It actually reveals a lot of troubling factors when it comes to Lincoln High School's security system.
How so?
Well, if you look at the chart under drugs confiscated on school property, for steroid pills and reefers, you have a number of 25, which is extremely large, especially in comparison to the other drugs that were confiscated on that same property.
Is there anything else that stands out to you on this chart?
Yes, the student population at this school is 1,000, yet they only have a total of 4 security officers patrolling the school.
And why is that troubling to you?
That's troubling to me because if you do the math, that's 1 security guard for every 250 students. That's very deficient, in my opinion. And with regard to the security officers, the way that they're utilized is also deficient.
Okay. Now, let's move on to step 2. What's step 2 of your analysis?
Step 2 of my analysis is, like I said earlier, I went to the school and I attended it for 10 consecutive days. There, I was able to not only interview students, but gain my own perspective as to how their security looks like from an insider's point of view.
And what did you find?
Well, I found, with regard to the school itself, they have 6 exit doors. And like I said, they have 4 security guards, but 3 of them are patrolling the school.
Now, these exit doors, why are they a point of contention or concern for you?
Well, they're a big concern for me, especially from a security standpoint, because like I said, the security officers are 3 patrolling 6. It's very easy for students to sneak in and out of these doors, and I even personally saw security officers permitting students to come in and out of those doors daily. I saw between 5 and 15 in a day come in and out this freely, and that's a very easy way for students to sneak drugs into a school.
Did you ever see students sneaking drugs into the school?
I saw in the hallway students exchanging cash for bags of white pottery.
Objection, Your Honor. The witness is testifying that what they saw is a drug exchange. However, that's outside of their personal knowledge. From a reasonable distance, you don't necessarily know what is being exchanged between two parties.
Your Honor, may I be heard?
You may.
Pursuant to Rule 701, the witness is allowed to testify based upon her perception of what she was able to see. Therefore, this witness has testified again that she spent 10 days at the school, and the witness has directly testified in regard to things that she found that students within Lincoln High School were partaking in.
Your Honor, if I may,
You may.
we don't object to the line of questioning as to that she saw something, but to specifically categorize it as a drug exchange when from a reasonable distance, again, there's no way to determine what that is the objection.
I'll allow her to testify as to what she perceived to be a drug transaction. You can certainly cross-examine her on,
Yes, Your Honor.
on her perceptions.
May I ask the question again, Your
You
Honor?
may.
What did you see the students exchanging?
I saw them exchanging cash for a bag of white powdery substance. I also saw students exchanging pills in the hallway.
Now, what was your overall conclusion that you came to under your expert capacity?
In my expert capacity, I concluded that the school security system was absolutely disastrous. I rated it a 4, and it's baffling to me because many of the school's problems have very simple solutions. Therefore, I offered them 8 recommendations on how to better improve their security system.
What were these 8 recommendations that you offered?
First, I recommended providing for random locker searches at least 5 times per month for the alternative glass see-through lockers. I recommended installing slide doors that can only be opened in the event of emergency, or at a minimum, installing chains on the doors, installing bells on the doors that could be warning signs, arranging for drug sniffing dogs on premises 2 times a month, hiring of 3 additional security officers, requiring photo IDs of staff and students, better monitoring of existing security personnel, forming a volunteer security corps that would help monitor school safety, and requiring random drug testing of all athletes.
No further questions, Your Honor. I'd like to save the remainder of my time for a possible redirect.
All right.
Your Honor, before we begin, if I may, since web years are conducted off the record, I ask that for judicial economy, my previous questions and answers be submitted to the jury for their consideration.
I'm sorry.
I'm sorry. Due to the fact that web years are conducted off the record, I'm just asking that for judicial economy, the questions and answers be constructively provided to the jury for their benefit.
All right, there will be some constructive debate.
Thank you.
Judge, would it be proper for when they speak wherever they are to move their
Sure.
face down? I'm having a hard time
I
understanding.
understand, I am as well. Objections from council's table can be made without the mask. Just very stating the objection.
Yes, Your Honor. May I proceed?
You may.
Thank you, Your Honor.
Hi, Dr. Garnett. Dr. Garnett, the second step in your process you just described is to actually personally visit the school for 10 days. Is that so?
Yes.
And you did personally visit Lincoln High?
Yes.
When you visited, you saw that they did have a metal detector.
Yes,
You saw that there were in fact some security guards.
there were some.
You saw posters around the school that warned against drugs and violence.
Yes, but students rarely pay attention to posters.
Thank you, Dr. Garnett. And you also learned of the policy that the school maintained for drug violations, correct?
Yes.
Dr. Garnett, I'd like to talk to you about your recommendation specifically, if I may. One of your recommendations, as you just stated, was for glass see-through lockers. Is that correct?
Yes.
Dr. Garnett, would it be fair to say that one of those lockers with parts and installation might cost $100?
It's possible, but my recommendations don't come from an accounting standpoint. It comes just from options to provide to the school.
Yes, Dr. Garnett, but it is possible that that's an approximate cost.
Sure.
Objection, Your Honor. Improper expert testimony. This witness was tendered as an expert in school security administration with a concentration in drug prevention and is not tendered, as she stated, as an accountant, Your Honor.
Your Honor, I'm not asking her to certify that she knows the effective cost of all the measures, but assuming that she provides recommendations that require a fiscal accumulation of costs, I assume that she knows of cost generally.
I'll allow the question and overrule the objection.
So, Dr. Garnett, if I may, that is a possible price.
It's a possible price.
Thank you, Dr. Garnett. Now, you also recommended emergency side-only doors, correct?
Yes.
And on your report, it states that one of those doors is approximately $30,000.
Yes.
Now, Lincoln High would need 6 of those doors, correct?
Correct.
Thank you, Dr. Garnett. Your other recommendation was for 3 additional security guards, is that right?
Yes.
Dr. Garnett, are you aware that the federal minimum wage is $7.25?
Yes.
Would it be fair to say, Dr. Garnett, that in order for a security guard to be effectively employed by Lincoln High, they would have to work roughly from 7 a.m. to 5 p.m.?
Sure.
Would it be reasonable to say that they would be doing that work 5 days out of the week?
Sure.
Would it be further reasonable to say that they would be doing that work for the 9 months approximately that most schools are in session?
Objection, Your Honor, outside the scope of the witness's knowledge. This witness is an expert security analyst and would have no idea of what exactly a security guard would do.
If the witness doesn't know the answer to the question, she can answer that she doesn't know.
Yes, Your Honor.
Dr. Garnett, I will repeat my question. Is it fair to say that a security guard would work for the 9 months out of the year that a school usually is in session?
I think it is reasonable, however, the school is who sets up their schedule. They may stagger them throughout the day versus having them work all day. They may stagger them through a month. That would be up to the school.
I understand, Dr. Garnett. Let me rephrase my question. Is it fair to say that they would have to work for whatever amount of time Lincoln High School is in session?
Yes.
Thank you, Dr. Garnett. Now, you made these recommendations to the New Columbia School District despite any budgetary constraints that they faced?
Right, I never take into consideration in budget. I'm coming to provide them options. They can choose from these options.
Of course, I understand, Dr. Garnett. And one last question. The New Columbia School District actually still currently owes you $3,000, correct?
Correct.
Thank you, Dr. Garnett. No further questions. I tender the witness subject to redirect.
Any regret?
Yes, Your Honor, briefly. Now, Dr. Garnett, mask down. They mentioned the security guards on cross-examination, so I want to revisit that topic. How many security guards did you see while you were at Lincoln High School?
I saw a total of 4.
And how many students are in attendance at Lincoln High School?
1,000.
So if my math's correct, that would mean that would be on average 1 security guard for every 250 students. Is that correct?
Correct. And one of those security guards stays in the front. He doesn't even patrol.
So that would mean so that would mean how many officers would be patrolling the school?
3.
And your expert opinions, is that an adequate number?
No, it's very efficient.
Okay. Now, these recommendations that you made for the New Columbia County School District and Lincoln High School, are they customary practice for someone of your field to make?
Yes, absolutely.
No further questions, Your Honor.
Thank you, Dr. Garnett. You may step down.
And with that, this concludes the case in chief for the plaintiff, Your Honor.
All right. The defense ready to proceed with this case in chief?
Yes, Your Honor, unless we'd like to take a recess.
Is that a request for a recess? Are
Yes,
yours doing okay? All right. You may call your first witness.
yes, Your Honor. At this point, Your Honor, we call Principal Terry Taylor to the stand. May I proceed, Your Honor?
You may.
Would you please introduce yourself?
Good afternoon. My name is Terry Taylor.
What do you do, Ms. Taylor?
I'm the principal at Lincoln High School.
Where'd you go to school for that?
Well, I started my educational experience with receiving a bachelor's degree in English from West University in 2004. Then I went on to earn my master's degree in educational administration from Ohio East University in 2006.
Now, have you always worked at Lincoln?
No, actually, after I graduated from Ohio East, I worked for about 2 years with the Ohio State Board of Education. After that, I spent 3 years serving as the assistant principal at Deerfield High School in Oakview, Ohio, before I was promoted to become principal at Deerfield in 2011. Then in 2016, I moved here to New Columbia to begin my job at Lincoln, and I've been there ever since.
And during the course of your career, have you ever spent any time working on reducing drug use or violence in schools?
Absolutely. That's actually become a bit of a specialty for me. When I was with the Ohio Board of Education, my focus was actually on curbing violence and drug use in public schools across the state of Ohio. And then I really had a chance to put that experience into practice at the ground level at both Deerfield and Lincoln High School.
Your Honor, at this point, we move to certify Principal Terry Taylor as an expert in the field of educational administration and school safety.
Any objection?
Yes, Your Honor. Permission to conduct a brief word out of the witness.
Permission granted.
Principal Taylor, you just stated that your bachelor's degree is in English, is that correct?
That's correct.
And what was your master's degree in?
Educational administration.
Okay, so do you have a degree in school safety?
My degree is in educational administration, as I stated, and I have obviously worked on school safety throughout my career
Thank
in
you.
schools.
Thank you, Principal Taylor, thank you. Do you have a degree in drug reduction and reducing drugs in schools?
No, I do not.
Principal Taylor, have you ever been published on this topic?
No, as I said, my experience with this topic is explicitly in practice in schools across Ohio as well as in New Columbia.
Your Honor, at this time, I'd like to re-raise my objection to Principal Taylor being certified as an expert in this field. Principal Taylor has not been certified in any reputable journals. She does not have a degree in the areas of interest that they're trying to proffer her in, and therefore she's unqualified to be admitted as an expert in this area.
Your response?
Your Honor, the qualifications that Mr. Marsh just listed are not a dispositive list, but rather a variety of factors that the bench should consider. Among those other factors are the extent and extensiveness of Ms. Taylor's career in this subject. She has been working in the field for the past 12 years, has received her master's degree, has worked for the Ohio Board of Education, and has been in charge of 2 different high schools. As such, she has more than enough expertise to be certified under Rule 702A.
Your Honor, if I may.
You may.
Your Honor, the fact that Principal Taylor has simply worked in these fields, not as a qualified expert within them, but simply as an employee capacity, I would argue there's no way that experience alone should be her qualification in order to be admitted as an expert.
Your Honor, the only requirement under 728 is having scientific, technical, or otherwise specialized knowledge. This witness clearly has that based on her years of expertise. There is no advanced degree requirement in either of those, in any field under 702A.
The court's ruling on this is going to be that that the witness does not necessarily, or has not been demonstrated to have the rigorous scientific, technical, and other specialized knowledge to be accepted as an expert to give opinions based on information provided by others. So the court will sustain the objection to hearing this witness as that expert. Nonetheless, the court will allow the witness as a lay witness to offer opinions based on her own perceptions that will be assistance to the jury. So you may receive your examination.
And Ms. Taylor, I'd like to bring your attention to Lincoln High School specifically. How did you come to be at Lincoln?
I was actually recruited by both the PTA and the New Columbia County School District. Specifically, they recruited me to address and curb school violence and drug use at Lincoln High School. Using my background, I've been able to make progress in both areas.
How did you start? Can you please describe Lincoln as you found it when you first arrived?
Well, put it this way. During the first week of classes after I arrived, a student died of a drug overdose in their homeroom. So I would say that drug usage and violence were both pretty prevalent when I first got there.
What steps did you take to correct this drug use and violence?
Well, right off the bat, I started a security committee that was responsible for generating ideas to create a safer school environment. I think it's crucial to mix not only my ideas and my experience, but with those of people who have been in the community for a while. So I put Pat Connor as the chair of that committee.
After creating this committee, what did you go about doing in the school to reduce violence?
Well, like I always say, to clean up a school, you need soap.
Soap?
It's just a little acronym I came up with to describe the crucial elements of crime prevention and drug safety when I was with the Ohio Board of Ed. It just stands for security, oversight, awareness, and punishment.
I want to walk through those each one at a time with you. Talk to us about security.
Well, security is twofold. The obvious thing that comes to mind is having security guards, which I hired several more of and brought our total number up to 5. But it also means the hall's security in general. We put up a metal detector, and I also took steps to limit entryways into the school from side doors.
What about O, oversight?
Oversight generally for us meant including law enforcement in our efforts. It's essential to get actual law enforcement involved as they have training and equipment that we just don't have access to. So once or twice a week, I arranged to have 2 officers come to the school, patrol the hallways with a drug sniffing dog. Obviously, we can't have officers everywhere all the time. So I also created an anonymous hotline for students to report any safety concerns they had.
What about A, awareness?
Awareness is all about bringing the students' attention to the potential dangers of drugs, alcohol, and violence. The fact is, pop culture drowns students with messages glorifying drugs and violence. Our best defense against that is to counteract that messaging with a real awareness of those issues. To do that, I hold periodic seminars with both students and faculty with several panelists to talk about the dangers of popular drugs. We also plastered posters all over the school for students' awareness.
Now let's turn to P, punishment. What does that look like?
Punishment is the most difficult part of my job as an educational administrator. Obviously, I want all of my students to succeed in life and to go on and do great things, but punishment has to be severe enough that it deters people, but not so draconian that it also would destroy a student's future. Honestly, I was kind of known as the enforcer around school because I took such a hard line against drugs and alcohol. But it's not just about punishing drug-related offenses. It's essential to enforce all rules at the school, especially rules like the side door rules. So since the use of side doors in a non-emergency situation is absolutely forbidden, we punish students who we caught using those side doors or even helping other students use them.
Now, after you implemented SOAP, did you notice any change in effect on the school?
Definitely. In the first year after I arrived at Lincoln, I expelled 30 students for drug-related offenses. The next year, thanks to the success of SOAP, we only had to expel 12 students.
Now, did the high school ever hire anyone to double check your method?
Absolutely. We had our school security committee, as I mentioned, but in addition to that, we retained a Dr. Garnett's services to conduct an analysis of the school, our current safety measures, and tell us ways we could improve.
Did you implement any of Dr. Garnett's suggestions?
Well, we were actually doing a lot of the things that Dr. Garnett suggested already.
Like what?
Well, we already had drug sniffing dogs periodically patrol. When I first arrived, I had hired additional security officers, and we already had a volunteer security corps.
Why didn't you implement the rest of Dr. Garnett's suggestions?
Frankly, they were unreasonable.
Why?
2 reasons, actually: legality and cost.
Let's talk about legality. What was what problems did that pose?
Well, there were a couple things Dr. Garnett suggested that I thought might be a smart call. But the attorney for the school district told me things like random drug testing required reasonable suspicion and that we couldn't just randomly drug test our students. One of the other things Dr. Garnett suggested we actually had tried before, which was putting chains on the side doors. But when we tried it initially, we learned that it was a fire code violation. I actually thought it was pretty odd that a so-called safety expert would recommend something that was against fire code.
Now, what about the cost?
I'll be frank, Lincoln High School is not in a good area of town. Like a lot of public schools, we just don't have access to the same kind of resources that other schools have. Some of the suggestions Dr. Garnett gave us might have been a good idea, but for us, they were prohibitively expensive.
Can you give us some examples of those?
Well, one of the things Dr. Garnett suggested was installing emergency-only doors. But she told us that would cost $30,000 per door, and we have 6 of them. Another thing she suggested was replacing every single one of our lockers with new shatterproof glass. We have 1,000 students, which means 1,000 lockers, plus the cost of installation for everything. You can do the math.
Were there any other unreasonable expenses?
Well, you have to acknowledge that hiring even more additional security guards at least minimum wage for an entire school year would be at least $15,000 per guard plus benefits every single year.
I want to change and bring your attention to Chris Wilkins. Are you familiar with Mr. Wilkins?
I am. Chris was a student at Lincoln High. He was a good track athlete. Lincoln, I make an effort to reach out to every single one of my students, and I did the same with Chris.
Can you please describe Chris Wilkins as a student?
Chris wasn't exactly a model student, but he was a good kid. Like most teenagers, he did have an attitude problem, and we had some definite concerns with his attendance, but Chris did great work on the track.
Did you ever attempt to correct Chris's behavior?
Of course. But honestly, without reasonable assistance from people in Chris's home, like his mother and father, there's nothing that I could do.
Objection, Your Honor. The witness is speculating as to the efforts of Chris's parents within their home.
Your Honor, if I may proffer, the witness will go on to say that despite multiple attempts, Chris's father only came up once to meet with the principal and Chris, and that was only with regards to obtaining a scholarship, not with regards to Chris's disciplinary.
Sounds like the witness will be testifying to what she herself perceived, so I'm going to overrule the objection.
Now, did you ever speak with Chris's father about correcting his behavior?
I did, only once though. Mr. Wilkins only ever came up to see me that one time, and it wasn't to talk about Chris's academics or attendance. It was actually to discuss giving Chris the Carl Lewis Scholarship, which we give to our best track athlete.
Now, are you familiar with a student named Dan Peters?
I am.
How do you know Dan?
Dan was a student at our school. In March of 2018, we caught Dan Peters smoking cigarettes in the bathroom. Immediately afterwards, he was brought to me and I suspended him for 2 weeks.
We've heard testimony today that Dan Peters actually was caught with marijuana and steroids. Is there any truth to that?
No, absolutely not. If Dan had had steroids or marijuana, I would have immediately expelled him.
Did you have any reason to believe that Dan Peters was selling steroids?
Absolutely not. Actually, after I suspended Dan that first time, it really seems like we set him on the right track. He made honor roll the second semester of his sophomore year, so it seems like things were improving with Dan.
Did you have any reason to believe that Chris Wilkins was using steroids?
Absolutely not.
Thank you. Nothing further, Your Honor. I tender the witness for cross.
Principal Taylor, you've been at LHS for 4 years now, is that correct?
I joined in 2016, yes.
So, 4 years. And you're of the opinion that LHS does not have a major drug problem?
Well, when I first arrived, we definitely did have a major drug problem. I worked very hard in concert with my staff to reduce that problem.
Thank you, Principal Taylor. So that is a yes to my question, though. You're of the opinion that there is no major drug problem?
There was, but we have definitely reduced it.
Principal Taylor, I know you're excited to testify and get to explain today, but simple yes or no would be okay. So that's a yes, that you do believe there's no drug problem at LHS at this time?
We have issues with drugs, but I wouldn't characterize it as major, no.
So Principal Taylor, within the 4 years that you've been at the school, you've expelled 42 students, is that right?
That's correct. We've been able to expel fewer and fewer each year from there.
And so if my math serves me correct, out of a student body of 1,000, you have expelled 4.2% of the student body at LHS for drugs.
We take it very seriously.
And furthermore, Chris Wilkins was not the first student to die of a drug overdose under your watch, is that right?
Well, I wouldn't say under my watch. Like I said, the first week after I arrived, a student died of a drug overdose. But after that, we made great strides with our SOAP program.
But you were the principal at the time that the first student did die, correct?
My first week on the job, yes.
And so Principal Taylor, moving on to safety measures. Did you ever install bells on the side exit doors to notify you if they were ever open?
No, we found that to be too cost prohibitive, and instead we just plastered the doors with posters alerting students to the consequences.
So you did put posters on the doors, but you never installed security doors that couldn't be accessed from the outside, right?
That's correct.
Okay.
Those doors would have cost $30,000.
Okay. You also told us that you never installed transparent lockers. Is that right?
That's correct.
And you also never conducted student-wide drug testing,
That's correct.
and you also never drug tested the LHS track team.
Like I said, I was informed by the district, by the attorney for the district that we weren't able to do that.
Thank you, Principal Taylor. Now, moving on to some things that you did do. You did host seminars, you told us, that were conducted by faculty, staff on various safety issues facing the school.
They were conducted by different groups of panelists for faculty, staff, and for students.
Thank you, Principal Taylor. But once again, a simple yes or no would be fine today. And then you also but you worked with local police. Is that right?
That's correct.
And you even arranged for drug sniffing dogs to come through the school?
Yes.
And Principal Taylor, would you agree with me that all of those efforts were relatively inexpensive?
We completed everything we were able to do that was within our reach.
And you also invested, though, $2,500 in brand new track uniforms, right?
That's correct. That money for the track team comes from a different part of the budget.
So you have no problem spending portions of the budget for brand new track uniforms that are very expensive, but you wouldn't go to the school board to ask for more funding for security, right?
Like I mentioned before, there are separate funds that are allocated for the track team, like the Carl Lewis Scholarship. That money isn't necessarily accessible for other things.
So that's a yes. You are willing to invest in the athletics, but not willing to ask the board for more money for security, right?
We invested as much of the money that we had available for security measures in security.
So Principal Taylor, speaking of the track team, Dan Peters was a member of that track team, as you've stated, correct?
That's correct.
And Dan Peters was caught smoking on school property?
Smoking cigarettes, yes, and we suspended him for 2 weeks.
Well, Principal Taylor, would you agree with me, though, that nicotine is a drug?
Nicotine is a drug, but obviously there are differences in the harmful effects of different drugs.
But Principal Taylor, there was no difference in your expulsion policy. A drug is a drug, correct?
We suspended Dan Peters for smoking cigarettes for 2 weeks.
So that's a yes to my question. There's no difference. A drug is a drug in your eyes?
Yes.
So Principal Taylor, you suspended Dan Peters, but you allowed him to remain a member of the track team, right?
That's correct. We suspended him for 2 weeks, and after that, along with Dan's mother, we had a conversation about.
And so you allowed him to stay on the track team, and you also provided him with a paid position mopping the floors of the school, correct?
Yes, we were attempting to help Dan through any forms of discipline and supervision that we could.
Thank you, Principal Taylor. Thank you. And this paid position, it allowed Dan Peters access to LHS before anybody else was there. It was unsupervised. Is that right?
That's not correct. He wasn't there before other people were there. He arrived before students did, but obviously faculty staff were.
But the students kind of helping them keep themselves accountable. That was a major portion of your security plan. Is that correct?
Student accountability and reporting was one piece of the many things we implemented.
And so you allowed a known drug dealer to be on school property on the campus of LHS without the presence of any of his peers to help supervise his actions?
Dan Peters was supervised by faculty and staff while he was on campus.
And so that's a yes to my question. You allowed a known drug dealer, Dan Peters, to be on campus before school, before the other students were present.
We had no knowledge of Dan Peters selling drugs, and he was present before students were, yes.
And Principal Taylor, though, you are aware, though, that it was Dan Peters that sold Chris the anabolic steroids that ultimately killed him, right?
Correct, but obviously we didn't know that at the time. It hadn't happened yet.
Thank you. Nothing further, Your Honor.
You redirect?
No, Your Honor. That's what it's be left step down.
Thank you. Ms. Taylor, you may step down. Does have any other witnesses?
Yes, Your Honor, we call Jamie Wallace to stand, please.
May go forward.
May I proceed, Your Honor?
You bet.
Thank you. Can you please introduce yourself to us, Jane?
Hi, my name is Jamie Wallace.
And Jamie, how are you related to this case?
Well, I was actually good friends with Chris Wilkins in high school. We were even best friends at a point.
How long have you known Chris?
Since I was a freshman at Lincoln High, so since 2015.
And how is it that the two of you met?
We both love to run. We actually were trying out for a spot on the varsity track team our freshman year.
Did you both make the team?
Not at first. I mean, I made the team, but Chris originally didn't. His parents, though, kind of pushed him to get on, and he eventually made the team.
Were the two of you always friends?
No, at first I couldn't really stand him.
So what changed?
We soon became friends. As our year went on, Coach Connor started giving us these brutal workouts at track practice. And normally after practice, Chris would run these extra laps just to show off, but one day he came up to me in tears. He said his times were down and not what his dad expected.
And what about that changed it for you?
Well, I mean, I put immense pressure on myself to be the best in all I can. And I realized Chris was under pressure as well. I guess everyone's fighting these battles and sometimes you can't see them,
As the two of you got closer, did Chris ever open up to you?
Yeah, we soon became friends and he started to tell me about these problems he was having at home.
What kind of problems?
Well, for one, his dad was crazy strict. I mean, Chris was supposed to go to school, track practice, and then head directly home. And all the time I knew the guy, he wasn't allowed to come over to my house to study or even go to a school dance. We weren't even supposed to talk on the phone.
Did that ever affect your friendship?
I mean, not really. We had school and track, and I'd go over to his house when his dad wasn't home. He normally worked until 9 at night, and we'd sneak out to the park sometimes to smoke and relax.
How was being on the track team together?
I mean, it was great. I love running. I still do it in college. Our junior year, Chris and I were trying to beat and best each other in the 100 and 200 meters.
Did you guys get to compete together that year?
Yeah, but our season got cut short. We didn't win our state championship, so we unfortunately didn't qualify for nationals. Chris kind of ran badly at the qualifying tournament.
And how did it feel not making it that year?
I mean, I was bummed. We all were bummed. And Coach Connor was mad, of course. She told us next season our team would stop nothing short of a victory, and then winked at us. And we knew what that wink meant. It meant running double drills all next season, which was gonna suck, but Chris seemed to take it really hard.
What do you mean Chris took it hard?
Well, I
Objection,
mean,
Your Honor. Outside the scope of the lay witness opinion, or outside the speculation, excuse me, Your Honor.
Your Honor, in the course of their friendship, these two students opened up to each other. She's just recounting what she heard from her own friend, and also Chris Wilkins is a party to this matter, and therefore should be permissible.
I'll allow the witness to testify to her impression about Chris today.
Yes, Your Honor. Jamie, could you go ahead and repeat your answer, please?
yeah, so the summer before our senior year, Chris seemed to take losing really hard. He just became so focused on improving his scores. He even showed me this magazine subscription his dad had got him. He was just obsessed with developing the right muscles, pushing to shave time off his laps. I mean, it was a little intense.
Did you two work together that summer? Work out together, I'm sorry.
Yeah, we were friends, but I wasn't going to the extent he was.
Did that end up affecting your friendship?
Not at first. I tried to be there for Chris. I mean, I'd always admired how steady his personality was. But that summer, he began to change. He started to act out.
What do you mean by act out?
Well, when senior year started, Chris started skipping classes, which was not something we did. And I noticed he was getting bigger and bigger, but he didn't appear to be working out as much. And one time I was joking with him like friends do, and he totally overreacted. He punched me. I don't know. I was just getting really worried,
Why were you getting worried, Jamie?
Well, Principal Taylor had posted all of these posters around our high school, and we even had a drug assembly to tell us about steroids and the symptoms of them. And the changes I was seeing in Chris
Objection, Your
were
Honor.
similar.
Improper expert opinion, Your Honor. This witness has testified that she barely has a high school education as a freshman in college, and if I may proffer, Your Honor,
You got it?
we have it on a good base authority that the opposing counsel is trying to elicit testimony that the witness suspected and speculated that the deceased Chris Wilkins was taking steroids, Your Honor. This witness has no prior knowledge and no prior educational experience in studying steroids because, again, she barely has a high school education as a freshman in college currently, Your Honor. And therefore, such testimony should be barred pursuant to Rule 702, Your Honor, as inadmissible testimony.
Your Honor, if I may. Jamie Wallace is not testifying as an expert to absolutely anything. As opposing counsel has stated, she just started her college education. However, Jamie Wallace is a student at Lincoln High School, attended the assembly that was held by Principal Taylor, that was there for the purpose of educating them on the signs and dangers of steroid usage. That is what she's testifying on, her experience from that learning experience at school and how it made her worried about her friend.
That be heard, Your Honor? The witness has already testified about the changes that she had seen to occur in Chris Wilkins and the attitude and behavior problems that Chris Wilkins had out of nowhere in the instance that she testified that she punched him. Then the witness testified about attending drug seminars that were held through the school. Once again, Your Honor, we have it on a good faith basis that the witness is trying to elicit or the opposing counsel is trying to elicit testimony that the witness is implying and speculating that the deceased Chris Wilkins was using steroids. And due to the fact that the witness that barely has a high school education, that is outside the scope of a lay witness opinion, as it is testimony about steroids has to be about testimony and experts has to be about specialized knowledge. And therefore, this line of questioning should be barred pursuant to Rule 702, Your Honor.
Your Honor, if I may. Jamie's not testifying to any type of speculation as to whether or not Chris Wilkins was on steroids because it is a stipulated fact within the packet that we all received. However, Jamie is testifying to the experience and knowledge she gained from joining those student seminars that were hosted by Principal Taylor in an effort to increase the safety and decrease the drug prevalence in the school. She's speaking only on her own experience within the school system itself as well as with her friendship.
I think the witness's testimony is reasonably based on her own perceptions and objection will be overruled.
Yes, Your Honor. Jamie, can you describe for me again why you were worried?
Well, Principal Taylor had all these posters about drugs around the school, and we even had this assembly where we learned about steroid use and the effects of it. And what I had learned seemed to be what I was seeing in Chris.
Objection, Your Honor. I'd like to renew my objection of eliciting an improper expert testimony.
Your Honor, if I may.
You may.
Jamie Wallace is not testifying to being an expert on the field. She's only giving her own present sense impression that resulted from those faculty held seminars and her relationship with Chris and the changes that she witnessed herself.
Your Honor, in order to testify in the capacity of an expert, they have to testify in regard to specialized knowledge. Anything regarding steroids would require some type of medical license to know to the degree of what the symptoms of steroids are. This witness has testified that she was a high school student at the time, and her only knowledge of knowing how these work is attending a special school seminar that was held at the school. Therefore, this is an improper expert testimony and should be barred pursuant to Rule 702, Your Honor.
Your Honor, if I may.
You may.
Jamie Wallace is not in any capacity trying to testify as an expert. She went to a seminar to decrease the use of drugs within a school, specifically steroid usage. During that seminar, she was warned of specific signs that one should look out for if there was the use of steroids. She's only discussing what she learned from that seminar held at Lincoln High School and what it caused her to believe in her friendship.
I perceive the witness's testimony as being that she is worried about her best friend's possible use of steroids based on information available to her. So don't consider that she's testifying as an expert. When we overrule the objection, that's certainly a matter you can explore or cross-examination.
Your Honor, may I repeat the question?
You may.
Thank you. Jamie, did you try to talk to Chris about being worried?
Yeah, I made it a point to talk to Chris, but when I did, he just got red in the face and he accused me of being jealous. He said I wanted to get him kicked off the team, which wasn't true. I don't know. After he reacted that way, I kept my suspicions to myself. I wish I didn't, but I did. And we just stopped being friends.
Jamie, when was the next time that the two of you interacted?
I mean, other than track practice, the last time I spoke with him was March 24th, the day of our tri-conference meet.
And what happened on that day?
Well, Chris and I were getting ready to run. We were warming up and all of a sudden he collapsed. So we crowded around him to make sure he was okay.
And what happened next, Jamie?
It was a blur. The next thing I remember, I found out Chris had passed away.
Thank you, Jamie. No further questions, Your Honor. We tender the witness subject to cross-examination.
All right. Mr. Cole?
Your Honor, can I have your thought, Will?
Yes.
And now, please reconstruct the will?
You may.
May I proceed, Your Honor?
You may.
Now, Jamie, you characterize Chris as one of your best friends, correct?
Yeah, we were really good friends in high school for a while.
Yet, you two didn't have the most flowery relationship. Is that fair to say?
At what point?
At the beginning, you two didn't have the most flowery relationship. Is that fair to say?
Yeah, at first I couldn't really stand Chris, but we became friends.
And that was because that you thought that he was better than everybody else. Is that correct, fair to say, at the beginning?
Yeah, he acted that way. He had just transferred from this rich school, so I assumed that was why.
So just for clarification, that's a yes to my question, is that right?
Yeah.
Okay. And it's also because, like, after practice, he would show off, right? And he would be running extra laps when everybody else was tired, right?
Yeah, he used to do that.
But yet, somewhere along the way, Chris began to confide in you. Is that fair to say?
Yeah, after he came up to me in tears at practice one day, I realized he was under pressure and we became friends.
Right. He began to trust you at that point, at that very point. Is that fair?
Yeah.
And when he confided in you, he told you that he felt like a prisoner in his own home. Is that correct?
Yeah, he did tell me that.
And that he wasn't allowed to go to any parties or dances put on by the school or anything along those lines, right?
Yeah, his dad was really strict.
And so it would be fair to say that you knew the negative implications of placing Chris in a precarious situation, right?
Can you rephrase?
In other words, you knew that if you were to go hang out with Chris, that you would possibly get him in trouble, right?
Objection, Your Honor. Relevance?
Your Honor, the opposing counsel opened that door in direct examination. I'm simply walking through it. And in direct examination, opposing counsel elicited the testimony that they used to hang out at their house and smoke. And so I'm simply just exploring that topic a little bit more, Your Honor.
I'll allow the testimony. The objection will be overruled.
Now, may I ask the question again?
No.
Now, so you knew the you knew the negative implication of placing Chris in a precarious situation, right?
I mean, I knew his dad was strict, so Chris was under pressure at home.
So you knew his dad was strict.
Yeah, he told me.
And you knew that you weren't allowed to go over to his house after practice, right?
I mean, I wasn't supposed to, but we'd hang out and do homework.
So you would go over to his house, right?
Yeah, we were best friends.
And all you would do is do homework.
I mean, sometimes we'd sneak out to the park and smoke.
So you would smoke cigarettes, so you would smoke marijuana around him, correct?
Yeah, Chris would smoke some cigarettes sometimes too.
And I want to explore that for a second. So the thing is, you and Chris were on the same track team, correct?
Yeah, we were.
As a matter of fact, you two ran the same events on the track team, correct?
Yeah, that's how we got to be really good friends. We practiced together.
And just for clarification, that's the 100-meter dash and the 200-meter dash. Is that right?
Yes, those were our top events.
And you would even go as far as to say that Chris's times at various points in y'all's track career was better than yours, right?
Yeah, we were always beating and besting each other. We kept each other on each other's toes.
But for a majority of your track period, his times were better than yours. Is that fair to say?
Yeah, Chris didn't start out super great, but he was an amazing track star by our senior year.
So, and that's a yes to my question, right?
Yeah.
Okay. So when you were smoking with Chris, did you ever try to make an attempt to stop him from smoking?
I mean, no.
Okay. Now, let's talk about Lincoln High School. You perceive it to be a safe place, is that right?
Safe as it can be.
Safe as it can be. Is this due to the signs that were posted everywhere saying that you would be expelled if you were to be caught with drugs in any kind?
Yeah, when Principal Taylor came, our school became much safer. It's in a bad neighborhood, so people used to bring all kinds of weapons to school, and it stopped when Principal Taylor came, for the most part.
Thank you for that, Ms. Wallace, but that's a yes to my question, correct?
Yes.
Okay. And it's also because of the security officers that were patrolling the school, right?
Yeah, there were 4 security officers walking around our school.
And there were 4. So let's talk about the security officers. One in particular, there was an officer, what was it, Officer Dan?
Yes, I think that was one of their names.
And this officer, he was what you say, he's like the pride and joy of their officers, correct?
I don't know about that.
And is that because that at various times that you would see him napping on the job?
I mean, it was rumored that he would take naps, but the other 3 officers were always around.
So that would mean that there are effectively 3 officers patrolling the school then?
Yeah.
Okay, so let's go to the day of March 24th, 2019, right? You were on your way to second period, right?
Yes, I did go to second period that day.
And you saw Dan Peters entering through one of these side exit doors, is that correct?
Yeah, Dan went to school with me and I saw him.
Now, a little tidbit about these side doors. They're prohibited to go through, is that correct?
Yeah, there are posters around the school saying we'll get in trouble if we go through them.
Specifically, when in relation to getting in trouble, you would be expelled, correct?
Yeah, and our Principal Taylor wanted every student to go through the front door.
And you saw Dan entering through these side doors, correct?
Yeah, it was really strange because he could have gotten in trouble.
And when he went through this side exit door, he met Chris Wilkins, correct?
Yeah, he stopped at Chris's locker.
And when he met Chris, he exchanged a bag full of some white pills in exchange for $10, correct?
Yeah, I wasn't really sure what was going on.
But you did see that happen, is that fair?
Yeah, I did.
As a matter of fact, not only did you see it happen, you saw it happen in the middle of the hallway, is that correct?
Yeah, in between periods.
And not only did you see that happen in the middle of the hallway, you saw Chris swallow all of the pills in the middle of the hallway, correct?
I saw him take maybe 3. I don't think it was all of them.
So, fine. You saw him swallow 3 pills in the middle of the hallway, correct?
Yeah, I think so. I was standing a little far away.
Okay. Now, let's go to the events that happened later on in that afternoon. And also, actually, I take that back. Dan Peters, he was a member of the track team, correct?
Yeah, he was.
So, as a byproduct, that means that he was up for the Carl Lewis Scholarship as well, right?
I guess technically we all were, but Dan wasn't a top runner like Chris and I.
But he was a gifted athlete, is that fair to say?
Yeah, of course. Everyone on our team was.
And Chris was also a gifted athlete, is that fair to say?
Yeah, he was one of the best runners I knew.
And Chris was also up for the Carl Lewis Scholarship, is that right?
Yeah.
And you were also up for the Carl Lewis Scholarship, correct?
Yeah, Chris and I were.
So, going to the events that happened later in the day, when you saw Chris collapse, you immediately ran to Chris's dad and confessed everything, correct?
Yeah, at that point, I knew I had to tell someone my suspicions. And when I told Chris's dad, he accused me of being a liar.
And when you confessed everything to Chris's dad, you told him specifically that you saw Chris and Dan engaging in a drug deal. Is that fair to say?
Yeah, I told him what I saw because I was worried. I thought it might help.
And tell me something. you were actually the recipient of the Carl Lewis Scholarship. Is that fair to say?
Yeah, I was.
No further questions, Your Honor.
Can you redirect?
Yes, Your Honor. Excuse me. Jamie, you mentioned that you spoke to Kyle Wilkins on March 24th at the tri-conference meet.
Yeah, after what happened to Chris, I went up to Kyle.
You specifically told him about your concerns and what you had seen.
Yeah, I was really worried when Chris collapsed.
And you mentioned that Kyle Wilkins didn't take that well.
No, he accused me of being a liar.
Jamie, at any point in time, did you hear or see Kyle Wilkins talk to the paramedics about what you told him?
No.
No further questions. Thank you, Your Honor.
Thank you. As well as you missed it.
With that, Your Honor, the defense closes case in chief. I'm going to ask for a brief 5-minute recess, prepare for closing arguments, and set up for.
All right. Thank you. The court will stand in recess for 5 minutes.
Go ahead and give your camera
All right, are we ready to?
This is my favorite letter, you guys see it all.
Court is back in session. Defense having rested. Court is, the jury having been instructed. We are ready to hear closing arguments. Does plaintiff wish to reserve any time for rebuttal?
Yes, Your Honor.
How much time?
The remainder of the time that I have, how much time do we have?
10 minutes.
So yes, the remainder of the time that I have left, Your Honor.
All right. You may proceed.
May I freedom of the court, Your Honor?
You may.
May it please the court, Your Honor, opposing counsel, members of the jury. How much is a life worth? Specifically, how much is a teenage life worth? It's a valid question. It's also a question that my co-counsel, Bobby Marsh, came before us at the beginning of today's proceedings to implant in all of our minds. But you want to know something? It's also a question that the defense refuses to even acknowledge. March 24th, 2019. A day that rocked the Wilkins family forever. Why? Because it was Chris Wilkins' last day on this earth. Kyle Wilkins would never be able to hug his child again. Kyle Wilkins would never be able to attend his high school graduation. Kyle Wilkins would never be able to help move his son into his first college dorm room. Wouldn't be able to attend his wedding, to hold his first grandchild. Why is that? It's because of the negligent actions of the defendant, because they refuse to provide an environment conducive to learning and safety, free of drugs. Time and time and time and time and time again, Dr. Terry Taylor, the principal of Lincoln High School, was given various recommendations in regard to how to fix the school's drug problem in particular. Dr. Taylor was given the recommendation of installing a side door that would only open in the event of an emergency. Dr. Taylor was given the recommendation of having bells implemented on the side door that would ring at the event that anyone tried to walk in or out of them. Dr. Taylor was given the recommendation of implementing school IDs, of implementing see-through lockers, more security officers. Did Dr. Taylor implement any of these things? No. And I know what you're asking. I know what you're thinking in your mind. Why? Why would this principal be so opposed to creating an environment that is conducive to learning and free of drug use? Why? Because they said that they didn't have any funding. What's even funnier is that they refused to even ask for any more funding. But you want to know what they did fund? New track uniforms. You know what that means? That means that the New Columbia County School District and Lincoln High School prefer their athletes to look nice over implementing the proper safety measures to keep their students safe on a given day of school. Now, as a parent, I want you to take a second and think about that. Imagine sending your child.
Objection, Your Honor. Call the rule.
Have you
Refrain from asking the jury to put themselves in the plaintiff's shoes.
It's fine, Your Honor. Ladies and gentlemen of the jury, this school was wrong. Track uniforms should not be there to be put in place over the safety of the students that they are sworn and have a duty to protect. And that is why myself, along with my co-counsel, Bobby Marsh, we are proud, no, we are honored to bring forth the claim of negligence against the New Columbia County School District. Now, what does that mean? We attorneys have this undying tendency to just make all these concepts sound a lot more difficult than what they really actually are. In order to prove that a person was negligent, there's 4 things that we as the plaintiff had to prove. We had to show to you today that the New Columbia County School District had a duty to provide a safe environment conducive to learning and free of drugs to all of their students. We had to prove today that the New Columbia County School District breached that very duty. We had to prove to you today that because of this breach, the New Columbia County School District caused harm to the plaintiff, Chris Wilkins. As a result, the easiest one, we have to prove to you today that Chris Wilkins died because of it. And we did prove all these things to you today, and we proved all these things to you through what's called a preponderance of the evidence. Now, what does that mean? It means that we have to prove to you today that the events that we as the plaintiff told you are more likely than not to be true. Think about it like a scale. If you were to place our side on one side of the scale, and if you were to place the defendant's side on the other side of the scale, if that very scale tips even slightly, and I mean even microscopically in our favor, then we've met our burden. And ladies and gentlemen, I'm going to let you guys in on a little secret, a secret that the defense doesn't want you to know. That this is the easiest burden to prove in our American judicial system. And we met that burden. We proved that burden. And how do we do it? Let's look at the testimony of everybody today. First, we call Pat Connor. Now, I want to say something about Pat Connor. Pat Connor was wrong. Or not. But you want to know the difference between Pat Connor and the New Columbia County School District? Pat Connor took that stand today and took accountability for her actions. She told us that the school district implemented all of these things that took away from the safe environment that they had a duty to protect for their students. Next, we called Dr. Devin Garnett to the stand. And Dr. Garnett took that stand and she testified about all of the various recommendations that she gave to the New Columbia County School District in Lincoln High School after she attended that school for 10 days. And she also testified about the safety conditions of the school while she was there, how it wasn't uncommon for students to sell drugs and to show up to school high. And then we heard from Dr. Terry Taylor, a woman who doesn't even acknowledge the fact that school even had a problem in the first place. Among other things that you heard from Dr. Terry Taylor today, Dr. Terry Taylor, I want you to understand this very clearly. Dr. Terry Taylor gave a job to a student, a drug dealer at that, and a drug possessor at that, of mopping the floors in an unoccupied school before school hours with little to no supervision. And why did she do that? Because he made the honor roll once. And then we heard from then we heard from Jamie Wallace, the living embodiment of the phrase, keep your friends close and your enemies closer. Jamie Wallace posed as a friend to Chris Wilkins. Yet Jamie Wallace did everything that she could to keep him close to him, to monitor him. Whenever Chris Wilkins did something to place him in his career and his future in a precarious situation, Jamie did nothing to stop it. Ladies and gentlemen of the jury, I wrote something down at the beginning of this trial, and I want to make sure that I get this correct. The defense got up here and told you that unreasonable expectations lead to unintended consequences. Well, I'm here today to tell you that it is not an unreasonable expectation to provide a safe environment to all of the students, conducive to learning and free of drugs. And it's for that very reason that, again, we are proud, no, honored to bring forth the claim of negligence against the New Columbia County School District. And that's why we, as the plaintiff, are asking you to find that the New Columbia County School District be liable for $5 million. Thank you. Your Honor, I reserve the remainder of my time for a possible rebuttal.
All right. Counsel for the defense.
May I proceed, Your Honor?
You may.
Your Honor, Mr. Coleman, members of the jury, unreasonable expectations lead to unintended consequences. Now today, Ms. Garcia started the trial out by telling you the facts that the plaintiff would like you to forget. Chris Wilkins was an average student, an average athlete, at a below average high school. His father tried out for the Olympics, didn't make it. Tried to vicariously live those dreams through his son. Had unreasonable expectations for how effective their son could be on the track. Even despite not making the team in the first place and then losing the championships for the team afterwards, his unreasonable expectation did not change. So Chris Wilkins, spurred on by his parents' unreasonable expectations, bodybuilding magazines, and fear of failure, chose to use steroids. He did so effectively that he evaded the suspicions of his friends, his track coach, and his parents. And on March 24th, he ingested his last pill and died. Now, ladies and gentlemen of the jury, we do not deny that this is a tragedy. We don't deny Chris Wilkins is no longer here among us, and New Columbia School District grieves the death of Chris Wilkins. But it was not the fault of Lincoln High School. See, Lincoln High School is a poor school in a worse neighborhood, operating on a shoestring budget. They hired Principal Terry Taylor to come in and clean up the school, and she did that with soap, remember? Security, oversight, awareness, and punishment. She even hired an expert, Dr. Garnett, to come into the school to double check her work. And when Dr. Garnett came to the school, she made 8 recommendations. Now, you heard Ms. Garcia talk to you about the cost, but I'm going to talk to you about the math. First of her recommendations was security doors that cost at minimum $30,000 a piece, and there were 6 to install. This unreasonable expectation cost $180,000. Their next suggestion was to hire security officers who, working for minimum wage, 10 hours a day, 5 days a week for 9 months out of the school year, cost approximately $15,000 a year, and wanted to hire 3. This unreasonable expectation cost $45,000, and that's a price to be paid every year. The last of her suggestions I want to bring to your attention is the see-through lockers. Dr. Garnett couldn't even put a price on how much that would have cost. She was offered $100. She had no idea. The price of this unreasonable expectation is literally incalculable. To fully comply with Dr. Garnett's recommendations, it would have required the school to find at minimum $225,000 on top of whatever these lockers may have cost. This is the same school district struggling to find an additional $3,000 to pay Dr. Garnett the remainder of his proper fee. These expectations were unreasonable. But what about the unintended consequences? Well, for that, we have to look at another fact the plaintiff would like you to forget, that Lincoln High School is first and foremost a school. Every dollar that's spent on these expenses, dollar that can't be paid for textbooks, lab equipment, computers, calculators. Ladies and gentlemen of the jury, there's a word for a building with those security measures without those school supplies. A prison. Now, despite these unreasonable expectations, the plaintiff has brought forth today a claim of negligence. They had to prove to you the New Columbia School District had a duty, that we breached that duty, that there was harm done, and that the breach was the cause of the harm. And we don't deny that we had a duty. Under the Safe Schools Act, we have a duty to our students to act as a reasonable parent would act under the same or similar circumstances. And we don't deny that Chris Wilkins was harmed. But ladies and gentlemen of the jury, New Columbia School District did not violate their duty. And anything that the plaintiff has alleged so far did not cause Chris Wilkins' death. Now, you may be wondering why we're talking about Chris and Kyle Wilkins at all. Well, in New Columbia, there is a thing called comparative negligence. You have the opportunity to look at all of the facts and determine who is actually at fault. Now, the plaintiff would have you believe that it was New Columbia School District and New Columbia School District alone that caused Chris Wilkins' harm. They would have you ignore the immense, unreasonable expectations of the father and the effects that it had on the son. They would have you ignore that Chris Wilkins evaded existing security measures to illegally obtain steroids and chose to use them himself. And that more likely than not standard that Mr. Coleman talked about earlier, that goes both ways. You can look at everything involved in this case and decide that if they have not shown that New Columbia School District is more likely the cause instead of any other source, and they have failed to meet their burden. They had to meet each and every one of these elements by a preponderance of the evidence, and they had to, if they have failed at any one of those, they have failed to prove their case. I want to take another moment here to talk about the term reasonable, because it's an important distinction, especially in light of what Mr. Coleman and Mr. Marsh have been telling you from the beginning. What is a life worth? It's an interesting philosophical question, ladies and gentlemen, but it is not the question today. The question today is not what is the most amount of money that New Columbia School District could have paid. It is what was reasonable for New Columbia School District. Now, the reason why we have a reasonable standard is because it's crucial. See, reasonable is that annoying answer that lawyers will give you to every single question. It depends. But while it may seem unsatisfying, it's important because it's the only thing that acknowledges that what's reasonable for a millionaire is not reasonable for a regular guy getting by on food stamps. What's reasonable for an Olympic level athlete is not reasonable for a kid who can't even make the track team. What's reasonable for a private school where tuition is thousands of dollars a year is not reasonable for a public school operating on a shoestring budget. Now, Dr. Garnett took the stand today, and you may have liked some of the suggestions that Dr. Garnett had. Dr. Garnett herself told you she doesn't make those recommendations considering the budget at all. And remember, ladies and gentlemen of the jury, that your job here today is not to decide whether or not Dr. Garnett's recommendations were good or bad. You have to decide if they were reasonable. Take our status as a school out of the equation. Imagine that we were a parent, because that's what the statute asks you to do. If the plaintiff hired an expert, and that expert told you that to be a reasonable parent, you had to have a nanny regardless of your financial resources, then if a jury held that, every single parent would be required to hire a full-time nanny, regardless of resources. Now, you and I know, ladies and gentlemen, the jury, that's an unreasonable expectation, and the unintended consequences would be devastating. Ladies and gentlemen, the jury, the facts are all out there. And it falls to you to make the crucial determination. What is reasonable? I ask that you find the only verdict that the evidence supports, the law requires, and that justice demands that you find New Columbia School District not liable.
How much time does Mr. Colton have for his rebuttal? 26 seconds. And I'm gonna make it quick.
Ladies and gentlemen of the jury, you heard 3 witnesses take that stand today. And they all talked about how they witnessed drugs either being sold or taken at the school. You heard today that there were 4 security guards for every 1,000 kids. You also heard that one of those security guards would nap on the job. Now, is this an environment conducive to learning? They said to clean up a school, you need soap. Well, due to the negligent actions of the school district.
You can finish what your sentence.
Yes, sir. They said to clean up a school, you need soap, but due to the negligent actions of the school district, their actions were about the equivalent of cleaning with soap and cold water, ineffective. Find them liable. Thank you.
All right. Thank you. The jury will now conduct its deliberations. The court will stand in recess.
All rise. Congratulations.
Sure, yeah. To come back? Yeah, absolutely. That's all good.
Yes.
One of them is now going to Northwestern, so she's in her MBA. And she and her husband are both in school together, so that's kind of crazy. And then as well, yeah. There's a couple other married couples in the program, but, it's kind of funny, yeah. I was teasing her. She's going to dating school. She's like, Mom, you don't go to dating school.
Okay.
Business school.
It's made up from announcements, but me too.
It's so much easier. Like, we get all these questions about getting married. 3 days show you. I'm like,
And I don't know the other part.
I didn't know it makes one. Yeah,
I'm so proud.
Good stuff, she's been right, and then, the other two are in New York today, so they're still up there. They spent a lot of time this summer, they tried to get out there, but it was so bad. Get this over from home, you know, it's probably accidents. I mean, that's they call it things. So, yeah. Like that, and they just everything else with us.
I think that you're gonna have stuff, you know, and I'm like, oh, yeah, so much Is there like, what's going on? Because you can just tell, oh, it's just not hungry. Yeah. Two or three times. About the state line.
Funny fact, you do know. Yeah, I'm married to it. Oh, yeah. And then she turned the camera and there you were. And for a while we were only married. Oh, wow. I'm looking forward to this. I spent a lot of time at good nights, especially before this competition started. Yeah. Next thing, I started to prepare for the next competition. I think all of them are going to be in spring, so I don't think we have anything else to worry about. I didn't think, but maybe. So far, all of them are Zoom. I think one is still holding out, and maybe in person. So we're still holding out to that. We're actually still in a holding pattern on a lot of the competitions.
Yeah, so right now, everything is completely online, it's great. But they say everything's gonna happen in spring, but so many competitions, they don't have a set date for, like, stuff that should, like AAJ, NPC, those that are put on by the bar associations or the bar divisions in those areas. They just have like approximate dates where they said it should be around this time, we will update as necessary. So I know NTC they didn't get like what it's outed, but like it should be the first. I know William Daniel will say specific things. So there are some that we know. I don't even think it's possible. As we discovered this week, it is possible to have an entire criminal. But
It came from kids. Yes. So basically, and then what we think
we definitely have enough spots extra for every. So no one gets we might even have options for multiple members. I don't know how we're doing that yet. That's still more to talk about. But for right now, competition so we can give them the option if they want to do it.
There's no requirement. It's not it's a lot of work to finish this competition and do it, and then decide when. I don't see that happening.
Which that's not kind of bad. I'd have to finish editing some of
That's what I was just saying. I had finished it. I'm tweaking it right now. Sitting here.
Look at the final edit. It's all right. That's good. Is it civil or criminal? Is it all? I don't know. I just know Aunt Claire asked me to make it juicy this year, so. Oh, I think
NTC should be criminal this year. NTC is criminal this year. They alternate between civil and criminal. It's 1 year civil, 1 year criminal, last year civil, so it should be criminal.
Okay. NTC, that's the young Texas.
The Texas Young Board.
Because I know Florida too, they're criminal. I think the ones we sign up for, I know at least NPC's criminal. Criminal.
I haven't been annexed.
William.
Okay, I
I'm
got
an
you.
alumni.
I got you. What is
I think the majority.
Nice to meet you. I'm Martin Cunningham.
Hi.
Which as much as I love civil cases, criminal is just a lot